I'm sorry, afternoon. There are quite a few people that are not yet logged on, but I'm sure they'll be joining us shortly. Hello, good afternoon, everyone. Welcome to PAYCO's November 30th installment of Legal Insights. Um, we are very happy today to have with us Dean Borger. He is a wonderful supporter of paralegals, not only here in Central Ohio, but also um, across the state and in West Virginia, Indiana, and I'm
DC.
sure other places. A wonderful supporter of paralegals, and we are very happy to have him with us. Dean Dean is with Borger Investigative Services, an outfit that specializes in an array of crucial investigative areas, demonstrating a commitment to excellence that has made them an invaluable resource in the field. Their core competencies include expertise in civil defense investigations, um, corporate investigations, and litigation support. Dean's agency has demonstrated its dedication to the pursuit of justice by engaging in court-appointed criminal cases involving serious offenses such as rape, murder, arson, and burglary. I think those are the big ones. Dean's extensive background is a testament to his proficiency and dedication. Before establishing his agency, he proudly served in the U.S. Army for a decade. Following his military service, he honed his investigative skills while working for a national security company for another 10 years. During this time, he specialized in labor and employment law investigations, adding to his comprehensive knowledge base. Um, Dean's reputation extends far beyond his successful career. He's authored numerous investigative articles. Um, I'm sorry, Dean, I'm trying to
I
paraphrase.
know it's kind of long.
He has had appearances on both local and national television and radio programs, and he is a sought after speaker on various investigative topics. We welcome you, Dean, and Dean is going to spend about 10 or 15 minutes sharing with us about his company. Welcome, Dean.
Oh, thank you again. I'm always so happy to see everybody's smiling face I've known for all these years. This year, I'm celebrating 25 years in business, having my own business. So it's kind of a milestone for me, and I'm excited about it and what we've achieved and all the presence we've done in the state, other states that we operate, and all the relationships I've developed along the way in the years that we've been in business. So, and I actually have a promotion. I posted this on LinkedIn. Can't really see it. I can send it to you, but uh,
Oh my.
if you've had an experience with our services and feel kind enough to give us a good review either on LinkedIn, on or Google. We put you in a contest here, and we do a drawing every quarter. We have one $250 winner. Then we have four different $50 Visa gift card winners. And actually, the 250 thing, I said either you can take it or we can donate it to a charity of your choice if you wish to do that as well. So we're excited about that. So I can send some information. I can send that flyer again on how to do that. But we appreciate the referrals, and I get a lot of referrals now, and I think that's a testimony to the work that we try to get the best results as possible when we're tasked with anything that we do, and go the extra mile to do that. I had the experience recently to give an expert opinion on background investigations on a case in West Virginia that now qualifies me um, uh, as an expert on background investigations in that state at least, and we've been doing it for years and so forth. So NALA, I think PAYCO's affiliate with NALA or NFPA.
NFPA.
NFPA. All right. Well, NALA, if you're a member of NALA as well, they'll be publishing an article I wrote on voir dire, which seems to be a little more prevalent these days, especially in West Virginia when I do a lot of coal mine cases down in West Virginia where they're really looking to see if the biases of the jurors down there, because a lot of cases, family members or jurors down there have had similar cases that may make them a little biased and being on a jury against a coal mine company or so forth down there. So I've been doing quite a bit of that. So I wrote an article about that. That's going to be published in NALA, I think on their online newsletter or however they're going to publish that. So yeah, stay in the business. I'm now retired. I still come to work every day, do this all the time. So just want to let people know that I still exist. So if you need our services or just want to talk or have a question about, hey, this is what I'm trying to do. I'm not going to tell you all my secrets, but maybe we can kind of discuss on, which way you should do it, things you suggest to your clients, because that's the ultimate goal. We want to be successful for our clients, making sure that they get the best optimal results in the end as possible. And so, yeah, feel free to give me a call, send me an email. I think you should. Everybody should have my contact information out there somewhere. I try to post on LinkedIn fairly often, just to keep up with everybody and in front of everybody to let people know we exist. So, appreciate the opportunity to speak with you again. Again, if you need anything, give me a call or send me an email. Thanks.
Great. Thanks so much, Dean. We appreciate you being here today. Also today, our speaker, thank you for joining us today, Judge Jeffrey D. Mackey of the Franklin County Probate Court. Judge Mackey was elected probate judge by the people of Franklin County, November 2020. He took office in February of 2021. By law, he serves as the administrative judge of the probate division of the Common Pleas Court and as clerk of his own court. He oversees the largest single judge court in Ohio, and his staff includes 60, including 14 magistrates. Judge Mackey graduated from the Ohio State University College of Law, and prior to becoming a judge, his practice was concentrated in estate planning, probate, and probate litigation. We welcome you, Judge Mackey. Thank you for joining us, sharing your expertise. We are very excited to hear what you have to share with us today.
Okay, well, thank you. Good afternoon, everybody. And I was pleased that you did not announce when I graduated from the Ohio State University College of Law what year that was. It was 1981, so I've been an attorney for 43 years. So I just look youthful on Zoom. But anyway, thank you for having me. Appreciate the invite. I spoke to this group 2 years ago, and now 2 years have passed. So we've got some updates to report to everybody. So I appreciate the opportunity to do that. As was stated, I was in private practice for 38 years before I ended up coming to the bench, concentrating on estate planning and probate, including probate litigation. So I came to the bench with very much a practical background, and I've tried to implement some rules to assist the practitioners in Franklin County and elsewhere to make things as easy as possible while still serving the 1.4 million people in Franklin County. So thanks for having me here. I do appreciate what paralegals do. We love paralegals. And I don't think she's here today, but one of my paralegals when I was in private practice was Miranda West, and I think Miranda is involved in your group and appreciate what she and everybody else does to serve the practice. My topic, what I really call this, and by the way, I was glad to see that Dean was going to be here. I know Dean, I worked with him when I was in private practice, so glad to see he's still out there kicking around and doing good work. So good afternoon to you, Dean. Yeah, I kind of entitled this presentation "View from the Bench." So I'm just kind of telling you things that I see that you may find helpful. I don't know how many of you that are on this are actually paralegals in probate practice or elsewhere. But hopefully those of you who practice in my court, you'll find some interesting things here. And by all means, if I don't know if somebody's moderating or monitoring the chat, so if somebody has any questions in the chat, if you want to just let me know that, and I'll try to address those on that. So Try to keep on schedule here. I've got two questions that I get that I want to address. And they sort of drive me both a little bit crazy. But the first one is I get questions of when is the court going to reopen? And that's a question that drives me crazy because the Franklin County Public Court has never been closed. During COVID, we had to modify some procedures, and frankly, these new procedures were put in place by my predecessor before I came on the bench. But the court has never been closed. We've always accepted filings, nothing has changed. Two things that affect the practitioners, and these again were changes that took place before I took the bench, but I continued them. We no longer have a duty magistrate desk where you can just walk in, get in line, and wait to see a duty magistrate, put some paperwork in front of them, and expect to walk out with some kind of a court entry. That was done away with for COVID reasons, number one, but also because it caused a lot of mistakes. Because you had a magistrate sitting there with a big long line of people waiting to get their entries approved, and they would have to kind of make some snap decisions, and it caused mistakes. So that was done away with by my predecessor, but I'm going to talk a little bit later about a process that we've had in place for quite a while where you can schedule consultations with the magistrate, but they're not a duty magistrate desk. Secondly, in the past, people could just walk anywhere around the floor, just walk around, flop down in front of a clerk, put some paperwork in front of them, and expect to walk out with some kind of approved entry. The court no longer allows people to just walk around and sit down in front of whoever they want to start talking to them. That is done for security reasons, certainly for COVID reasons, and also for reasons that you may not fully appreciate, and that is, I mean, a lot of you know my staff, they're very likable, you're very likable, and so you sit down and you have a social chat with them for 15 to 20 minutes. Well, that takes a lot of their time. So not that they don't want to chat with you, but they can't chat for everybody at 15, 20 minutes per person, that this is not an efficient way of doing things. So when you come to the front reception area, if you have to talk to a particular person at the accounts desk or whatnot, all you need to do is just say, hey, I need to see so-and-so at such and such department. They'll be paid, they will come out, they will talk to you, and if they feel it's helpful to bring you back to their desk and sit down and take care of your issue, then that's fine, but that's their fault. So the fact that we don't allow people to just wander around on the floor, and again, that's for security reasons and other reasons, doesn't mean that the court is closed. We just are implementing some procedures that every other court in Ohio is implementing. So when is the court going to reopen? It's never closed. First question. Second question, when are we going to get 100% e-filing? About 12 years ago, the probate court instituted e-filing in certain areas. They didn't jump in 100% because they were kind of a little queasy about doing this, and so they kind of took baby steps. And so the estates and the guardianship areas are not e-filing. They were paper filing. If we had done this all 12 years ago, we'd have been way ahead, but they chose not to do that. Now we're paying cost for that. We, the Franklin Probate Court, are part of a larger county-wide new case management system upgrade. It's going to be about a $25 million project, probably about 5 years into it. It has not gone as smoothly as we would have liked. Originally, we thought that the Franklin Probate Court, this would be done and we would be completely e-filing by probably the fall of 2022. Here we are, almost 2024. We are not there yet. So we're still working on that. That's no fault of the probate court. We're working with maybe some other workarounds where we can get 100% e-filing, even though the whole case management system is still up and running. So when there will be 100% e-filing, I don't know. We will give everybody plenty of advance notice so that we can be aware. And we're also going to do some training sessions and some tutorials to give the practitioners some advice on how to do this. But I think everyone's familiar with the concept of e-filing. Most other courts have been doing this for years, and probate courts have been doing it in certain areas now for about a dozen years. So when will we be 100% e-filing? I don't know, but hopefully soon. Those are the two questions I just wanted to address, and hopefully that's answer some questions that perhaps you've had. So I'm going to jump into some other kind of random topics. And again, if anyone has any questions, by all means, just put some in the chat or whatever, and I'll try to address those as we go along. We do have some new, well, they're not so new at this point, some administrative orders. Those are like local rules, but they're a lot easier to implement. And they're on our website. And unfortunately, they're not the easiest place to find. I think they're in the local rules dropped out. There's some administrative orders. I'm just going to go over a few of those that recently did implement just to make sure you're aware they exist. And maybe in order of when we implemented them. One was about release of administration cases. And again, for those of you who practice in probate, you may get involved in release of administration. I know I did probate practice for 38 years, and attorneys don't like to do release of administration. They're in some ways more burdensome than a full administration. That's because the way the statutes are set up. They don't pay very much because you're dealing with relatively small estates. There's about 5 different categories of release of administration. So typically, there are estates where there is a surviving spouse and you're talking about assets of $100,000, the probate assets of $100,000 or less, or when there is no surviving spouse, probate assets of $35,000 or less. But they're not big estates. They're kind of burdensome. Attorneys don't like to do them, but they feel like they have to charge for that. And I've been preaching this for some time. The Franklin County Probate Court has a resource center. You can access it on our homepage. There's a drop-down resource center. We have an attorney who's done this for years and years. He's a contract employee, and he represents applicants and clients who have release administrations, all 5 of the different categories of release administration. He does this for lay people at no charge. So oftentimes, if your attorney has a client who reaches out and says, "Hey, my grandma died. She's got a car and some bank accounts. I guess we need to do something." I think the attorney can tell the client, "Well, thanks for reaching out, but guess what? I can get you the result you want at no charge." And you need to reach out to the Franklin County Probate Court Resource Center, and they have somebody who will evaluate the case, determine what process you need to go through, and will do this for you at no charge. And so the attorney then they're a hero to the client because they say, "Gee, I'm getting the result I want. I'm not going to pay anybody." That's great. The attorney doesn't have to do it. Deal with all that headache. I mean, they're going to lose a couple dollars of fees, but usually the fees in release administration are very hard to earn fees, and nobody likes to do that. So this resource center, the gentleman who does it, Ray Perillo, first he'll talk over the phone with the applicant, with the client, and determine whether the case is even appropriate for release. It turns out maybe the decedent is a resident of a different county, and he'll say you need to reach out to Delaware County or whatnot. You're not even in the right county. Or, gee, when you throw in the house and the other things, you're above the limit, so this is not even a release case. Therefore, the resource center will not assist you in doing this. So that process of even evaluating whether it's an appropriate release administration case is very helpful. So again, if attorneys want to do these releases, knock yourself out. I'm not telling you not to do them. I just know attorneys don't like doing them. Here's a process where they can become a hero with the client for getting it done at no charge. So then, next year when that client gets run over the crosswalk, they'll come back to the attorney and say, "Hey, guess what happened to me now? And you were so great and helped me with that probate matter. I want you to represent me in this other matter." Or come back and say, "I'd like you to be my own estate planning now because I think people did such a wonderful job." So we have an administrative order about release of administration. Now, the order also talks about attorney fees. It talks about attorney fees in a release of administration should not exceed either $750 or 2.5% of the assets involved in the release, whichever is greater. Because what we see down here, and it kind of drives us crazy, we'll see a very small estate, a release with just maybe a few $1,000s in it, and the attorney fee is like over $2,000. So the attorney fee is eating up almost all of the assets. We find that a little troublesome because since we have a process that can be done for free, and these are not that complicated, why do we see attorney's fees that are so high? So if your office is doing release of administration, make sure the attorney is familiar with our administrative order regarding attorney fees and release administration cases. So that's one administrative order. Second is there's a fairly small number of attorneys, not really, it's a lot of time on something that doesn't affect a lot of you, but there are a number of probate lawyers who handle the probate part of wrongful death cases. As you may know, if there's a wrongful death case, the settlement, that is the amount, and then more difficult, the distribution of the wrongful death proceeds is something the probate court has to prove. We have to look at the settlement, see if it's appropriate, and that's usually not an issue. The more complicated issue is who gets the money. It is a fairly subtle and complex issue because it's not just next of kin. It is, there's another category, other next of kin. So this has been something that the probate bar deals with to help the personal injury lawyers take the wrongful death cases through the probate process. So the probate attorney represents, in essence, the plaintiff's attorney, the personal injury lawyer, in taking the wrongful death settlement and distribution through the probate court process. We would see attorney fees in these all over the place. So we just get a handle on what was appropriate, what was not appropriate. So the issue of the attorney fees and for the probate attorney in wrongful death cases, we've addressed that. We've discussed this with probate attorneys and also the personal injury lawyers. And we are putting on an administrative order that has not yet been finalized to assist the probate lawyers in determining how to handle their fees in wrongful death cases. Having that said, we do have a current administrative order that's going into effect about July, and this is due to a state change in the statute, and it affects decedents with a date of death on it after April 4, 2023. So we haven't really been seeing a lot of these cases. But the legislature changed the process for probate court involvement in wrongful death cases. What they were trying to do is button down this issue of who are the heirs that need to be notified so they can present their claim, present their argument that they're entitled to X number of dollars from wrongful death proceeds. I think that I've been preaching this for quite a while to keep probate lawyers from commit malpractice. I think they all pretty much understand the process now. But if any of you have attorneys that deal with probate aspects of, or I suppose even if you're paralegals in injury firms, they all need to be aware of the changing law in the wrongful death proceed process for dates of death after April 4 of this year. It again is an effort to try to make sure that people who believe that they're having some money have a process for presenting their argument. That's another administrative area that's been happening out for about half a year. Another change in the law is the fact that we've had to inform attorneys about is creditors' claim. There was also across the state. There's been a variety of ways in which creditors present their claims, and whether they should be presented to the probate court or not. The statute never allowed a process for creditors to present their claim against the estate to the probate court. It's supposed to be presented to the fiduciary or another way. So that law changed, and this is not just for dates of death after April 4. This is for anything that happens after April 4 this year. So now a creditor can present a claim against the estate to the probate court, and then they're supposed to also serve that on the estate fiduciary or their attorney of record, and then file a certificate of service. So we can be the party where a claimant creditor can file their claim with the probate court, and that's all well and good. So hopefully that means that the fiduciary and hopefully also the attorney know about that claim and they can resolve it, either accept it, reject it, whatever. So on the final account that gets filed by the attorney, there's now a paragraph in that account that the box is supposed to be checked, where the fiduciary or the attorney, it doesn't really matter, it says on the final account, we have checked the Franklin County Probate Court docket to make sure there are no claims that have been presented in the estate that have not yet been resolved. And resolved really means either accepted or rejected. So that box that's on our form, that box needs to be checked to say, yes, we have checked the docket, those claims have all been resolved. If you're using old forms that don't have that box on it, you could submit a separate statement, and we don't care whether it's been signed by the fiduciary or the attorney, that basically says the same thing. If it's not on your account form, I think that's 13.0 if I'm not mistaken, then it can be filed as a separate form. We need to know that before the final account can be accepted, that someone, the fiduciary or the attorney both, are certified that there are no unresolved claims. So make sure on your final account form, we don't care about it on partial account, but on final account, and you need to tell us that you checked the docket and there are no unresolved claims. Otherwise, your account's going to get rejected. So those are some current administrative orders that are at play. So if there's a question here in the chat. Okay, but that's not good. No. So those are some administrative orders, and you can find those on our website, on the, in the local news section. We are also going through, we do a process every 2 years of revising our local rules. And certainly those are, what we tried to do is we've done this 2 years, every 2 years. We went through a process. We tried to be very proactive with the local practitioners. We reached out to a lot of them. We had sit-down meetings with them. We came up with some proposed local rules. We read all of them for comment. And now we finally come up with what we think are the appropriate proposed local rules. And they're on our website for comment, for public comment. They're on the website November 15th, so we've done it about 2 weeks. So we'll take public comments, and then by the end of the year, we'll finalize them, and then they're going to be presented to the Supreme Court in January 2nd, I guess, of 2024. So part of what we're trying to do is implement some procedures that are going to be a little more clear that we want about what the probate court expects. Some of those, it may put down in writing practices that we were already doing in the probate court. We just want to make sure everybody can see it in black and white. Here's what we expect in different areas. It's also helpful to the out-of-county attorneys. If they have a special thing they have to file here in the Franklin County Probate Court, most attorneys would check the local rules in that county wherever they're filing, just to make sure they're up to date with what the process is in that particular county. I have kind of a funny story, and this was a county that'll rename this, but it happened to be Morrow County. This was like probably 10 years ago. I had something in Morrow County, so I looked for the local rules. I couldn't find them, so I called the chief deputy clerk in Morrow County. I said, I had a question about the local rules. I can't find them anywhere. She said, oh yeah, we get that question all the time. We don't have any local rules. Do you think we should get some? And I kind of said, yes, if you want, I'll help you draft some at no charge if you want. But yeah, do I think you should get some? Yeah, it's probably helpful. I know they have local rules now, but I just thought that was funny. It's like, yeah, we get that question all the time. Do you think we should get some? Like, and just go to the local rules store and buy some local rules. I didn't know what she meant by that, but the local rules can be helpful. If you have a particular situation like me, yeah, look at our local rules, and you might get some guidance there, and you might say, oh, I didn't know that's how the probate court wanted us to do that thing. And I want to circle back a little bit. I talked about the presentment of creditor claim. We had kind of a quirky rule in probate court about creditors who wanted to present a claim to the court. The statute never really authorized that. So we had a civil action that could be filed called a creditor's claim. It's a civil action between plaintiff and defendant, and people got notice of the claim and whatnot. And it was a very cumbersome process. So I think this new presentment of claim administrative order, which is also incorporated in our local rules, is going to help creditors determine how they should, very, very simple process, how they should present their claim to the Franklin County Probate Court without going through this big complicated civil action. So we're trying to do some administrative orders and local rules that are making the practitioner's job easier. So the local rules are out there again on our website for comments, so you might want to let the attorneys know if they want to look at it, if they have any comments, by all means, submit those, and we'll determine how appropriate it would be to include whatever suggestions to the attorney. Okay, some other very practical things we're going to talk about. It's about 12:30, so I got plenty of time. And some of you may be familiar with our drop boxes. You can come to the 22nd floor. There's a drop box. They can put your filings in drop box. You can even hand them to the receptionist if you really want to make sure that somebody's got them. That's probably not necessarily the drop box. They work perfectly well. But then during COVID, we also have a drop box on the first floor in the lobby. That's not as relevant anymore. So we're doing away with the first floor drop box at the end of the year. So it hasn't really been announced yet. You're the first people to hear this. So the drop box on the first floor is going to be done away with at the end of the year. It also is kind of labor intensive. So they go down at the end of the day every day and clean out and empty out the drop box on the first floor in the lobby. So that's going to be done away with. So if you want to start going ahead with the statement again with the drop box on the 22nd floor, that's probably going to be a better option for you. I talked about we don't have a magistrate duty desk anymore, and that was done away with under my predecessor. They might continue that, but we do have a process that's been very, very successful. And that is, you're not coming down and waiting in line and then sitting down face to face with the magistrate. The attorneys and I guess the staff also can schedule a consultation with the magistrate. The process used to be you call a magistrate's assistant and then they would try to schedule a consultation. It could be with a particular magistrate, that's who you want to talk to, as long as it's not a pending case that has a controversy and you don't want ex parte communications from one side of the case. But if you want to talk to a particular magistrate, because you know it's an adoption case and not certain magistrates, like 14 magistrates, certain magistrates who kind of concentrate on adoption cases or maybe a trust matter, and I have a couple magistrates who are really good with trust matters. So if the attorney wants to have a consultation with a particular magistrate, that's fine. If they don't care who they have the consultation with, that's fine too. The problem with the process with the phone call, there was a lot of phone tag back and forth. So now we have a self-scheduling opportunity if someone, an attorney, could be a paralegal also, wants to have a consultation with a magistrate. It could be, typically it's over the phone. It could also be by Zoom. It could be in person, but only if the magistrate is okay with that for COVID reasons, medical reasons. So typically it's a phone conversation. So if you want to have self-schedule a consultation with the magistrate, you can do that. We tried to kind of hide it a little bit on the website because we didn't want lay people trying to schedule consultation. It's for professional. And so what you need to do is you need to go to the probate court homepage, and there's a drop down called About, ABOUT, About. So you go to the About drop down, and then there's a section here called E-Meeting Locator. Now you may have used that past just to schedule a hearing, but the E-Meeting Locator is what you would use to self-schedule the consultation with the magistrate. So you'll go to one of our magistrate's assistants, and then they will confirm the magistrate's available. Then we've had it now for maybe a month or so. It seems to be working very well. So self-scheduling of a magistrate consultation be done on the homepage. About and on a similar note, to assist attorneys and paralegals if they have emails they want to send to the court, maybe a professional question of some sort, maybe a question specific to one question for the magistrate. We now have a dedicated attorney email address, and this has also been in place now for a matter of weeks. And the email address for the dedicated attorney email is probate.legal@franklincounty.ohio.gov. So it's probate.legal@franklincounty.ohio, and that's all one word, franklincounty.ohio.gov. And that's working very well. So if you have any problems with that, I mean, the problem was if you emailed something to the court, it went to our certified desk. They were the kind of the recipient of all the email, and they may get 100, 150 emails every morning, and it would just take sometimes to sort through to get the ones that the attorney had specific questions on. So we thought it was a nice feature to attorneys have their own dedicated email address.
Judge Mackey, may I ask a question? When I have contacted your court from time to time when I need copies of certain documents from a docket, and I believe I send that to probate@franklincounty.ohio.gov. And I always get a good response, but while you're talking about this, is that the continued method to obtain copies?
Yeah, I would say if you want copies, certified copies or other copies, I would say send that to the general email. That's because that goes to the certified desk, and they're the ones that
Okay,
copies.
so that doesn't change. That
that's a good
doesn't change
question.
from what
Yeah.
we've been doing. All right.
You certified copies. Go ahead and just send that to the general email box. This is more for specific legal questions. So that's a good question. Congratulations.
Okay, thank you.
And they do respond. I thank you for the compliment. They do respond. They're very appropriate. And now that they're not going to have to deal with all the attorney inquiries, it's going to let them even focus more on their job of getting copies that are certified copies really well. When I was in private practice, I had no idea that the certified desk did so many different things. I thought, okay, you get your certificate of transfer approved, and then you walk over to the certified desk, they certify it. I didn't realize pretty wide group of tasks that the certified desk does. So this just to let them focus on what they do and let the magistrate's assistants deal with the specific legal business. As part of filings by fax and by email, this kind of came in during the COVID process. It could be sometimes it's difficult for attorneys to get something signed by a fiduciary or signed by a beneficiary because it's COVID, nobody wanted to see anybody. So we did allow filings by fax and email. But two comments on that. First off, it needs prior approval. And typically that would be approval of whatever department is giving. So if it's a filing of account, get approval of the accounts department. You don't have to get a magistrate approval. So you need a court approval in advance before you do that. And it's just either a magistrate or probably more appropriate that particular department. And secondly, if you're filing something by fax or by email, we're talking really relatively small number of pages. We do not want 100-page account being filed by fax or email. Our system isn't really set up for that. We can't accept 100-page faxes or 100-page email. So if you are filing something with prior approval by fax or by email, yeah, keep it to a reasonable number of pages. And I think, as you all know, if you're filing something with the probate court, the case number needs to be on every page. So if you are filing, paper filing of an account and it has like tons and tons of pages, well, that's fine. We don't care about that. But make sure you have the case number on every page. Sometimes staff just goes ahead and likes to go and they go ahead and write the case number or stamp the case number on every page, but that's really the responsibility of the file. And also, I think this is the rule in a lot of courts for a lot of time, that is redaction. We don't have social security numbers and things of that sort of filing. It is the responsibility of the filer to redact social security numbers and other confidential information. That we hopefully will catch that if we get something that comes in. The death certificate, for example, we don't need the death certificate number. We don't want the social security number in the death certificate to be redacted. Okay. Things that are never said. Oh, everyone's asking about the email for sending legal, but probate.legal@franklincounty.gov. Yes, if that doesn't work, I gave you some information, but that should work. Always like to let people know. I know probably your attorneys are busy, you're busy, you really don't need any more work, but we do have a lot of kind of rewarding opportunities for appointed work. And this is not pro bono legal aid work. This is stuff that people the attorneys get paid for. I think a lot of times the attorneys don't realize, especially younger attorneys, it's a great opportunity for younger attorneys to learn some things, to get paid in the meantime, form relationships with the probate court, and also get the undying love and admiration of the probate judge. So we have legal appointment opportunities, and if any of your offices do adoption, you might be familiar with a Supreme Court case that ended back December 2020. So it came in a month after I was elected, but before I took the bench. And there was a case called NRA YEF, or their initials of an adoption. So, and this is where the Supreme Court said that parental rights, adoption rights are fundamental rights, and therefore birth parents whose rights are being taken away by adoption have a fundamental right to have court-appointed counsel to represent them. Well, this kind of came out of nowhere. It was like, oh my goodness, what do we do? So it's been quite a controversial, not so much controversial, just complex issue. How do we get attorneys that we can appoint to represent birth parents? For those of you who do adoptions, that typically is when somebody's alleging that their birth parents' consent is not necessary because they haven't had the appropriate level of contact or financial support for the kid. So this YEF case required us and all the courts in Ohio to adopt processes to get court-appointed counsel for birth parents. And we've got attorneys, Capital Law School volunteered, they stepped up and we're doing this for a while on a free basis, but they don't do that anymore. So we do have a list of attorneys who are willing to do this. They get paid for doing it. I say it's not terribly complicated because it's really a factual issue of whether the birth parent consent is necessary or not. But it does pay, and even if your counsel in your office is not an adoption expert, it's not that difficult to get brought up to speed on that. So if you do want to get involved and inquire, if any of your attorneys want to inquire to court-appointed counsel for birth parents, they can reach out to the court. It's like what's involved in that, how much it pays. The pay is not bad, it's not bad pay. So that's one court-appointed opportunity for attorneys. Also, court-appointed counsel for alleged incompetence. Somebody there's been an application filed for them to be put under a guardianship. They are disagreeing with that. They have the right to have an attorney appointed to represent them as an alleged incompetent. These things happen very quickly. Usually they happen on a fairly quick basis. They get paid for it. The attorney gets paid for representing the alleged incompetent. Gets paid by the court, nothing else. And the important thing is the attorney, if they get appointed to represent the grandma or whatever, if it's an alleged incompetent, they only are representing the person through the appointment. And if the court determines, yes, the guardianship is necessary, and appoints a guardian, the attorney's done. They are not grandma's attorney for the rest of her life. It doesn't stick on their shoes like, like tar or something. They only represent the alleged incompetent until the appointment hearing. The court says, no, my grandma looks perfectly competent, if this is the case, or we're going to appoint grandson as the guardian. The attorney's done. So I think sometimes there was this misunderstanding that they were just stuck being grandma's for the rest of their life. So that's another opportunity to get involved with something before it comes to work. It's not complicated. Your pay is not bad, and it's a good way to learn some things, especially if you're a younger lawyer, or you're a lawyer who wants to maybe expand into practice. It's a good way of doing that. And we're always happy to sit down and talk with somebody and say, here's what's involved in these cases. Here's why it might be a good opportunity for you to look into that. Also, we have cases where a guardianship has already been established, and then for some reason, either the guardian resigns, and I've done this for years, I'm just tired, I don't want to do it anymore, I don't want to be grandmother, or moving to Idaho, and I can't do this anymore, so I'm resigning, and nobody else steps up to the appointed guardian. We have opportunity for attorneys to be appointed as guardians, could be guardian of a person, or guardian of the estate, or both. Also, in cases where perhaps the attorney hasn't resigned, maybe, sorry, the guardian hasn't resigned, but the guardian has been removed. They're not doing their job, so they get removed. They need to appoint someone else, and I think the doesn't step up to do that. So there are opportunities for attorneys to be appointed as guardians, either of the person or the estate, or both. And again, the pay is not bad. It's different whether it's guardian of the person or guardian of the estate. That we have specific schedules and whatnot for the compensation, and it's not bad. So I just want to make sure that you are aware that you have various court appointment opportunities for attorneys who want to do it. I mean, I'm not saying everybody's just doing it because of the money. You could be saying, this is a service that I'd like to provide, and I just happen to get paid in the process, and that's great. But again, this is not legal aid. It's not free. These are court appointment opportunities, and we'd be happy to discuss that with anybody who might have something in that. So, I think that's about the end of my babbling. I hope I've answered some questions and maybe raised some issues where were issues. So I don't really see any other questions in the chat. So other than the chat, does anyone have any questions or any comments they'd like to make before we wrap up early? That's fine. That's never a problem. But I'm not getting CLE for this, so I don't have to fill up the entire hour. So any questions anyone has, either in the chat or okay, well, again, I'm really serious when I guess I will make one more comment. It's an interesting follow-up. When I talked to this group 2 years ago, I went around and talked to all my staff, and I said, is there anything you want me to discuss with the paralegals and raise an issue? And an issue I heard then, which I would say is a little icky and a little uncomfortable, but sometimes we get the comments, they said, paralegals come down here and their attorney has tasked them to get this thing filed, get this entry approved. And they come down, and for whatever reason, my staff rejects the filing, it's not appropriate, it's wrong, whatever. And we used to get issues where, that's what used to, where the paralegals would argue with the staff, say, no, we're doing it this way. And they would kind of harass the staff, hoping if they harass the staff maybe long enough, eventually they would say, okay, fine, whatever you want, I'll go ahead and approve that. That was not appropriate. So if any of you want to file, that's not appropriate in court. You have something that you're trying to file in the court is rejecting it for whatever reason. I understand you're under some pressure from your attorney to get this thing approved, but arguing and harassing staff is not the way to do it. They know what they're doing. And if they're saying you need to do it this way rather than your way, you need to say, thank you for informing us of that process. We misunderstood that. I will go back to the attorney, we will get it done correctly. And thank you for bringing that to our attention. My staff says that's not so much of an issue anymore, and I don't take credit for that. It's not because I brought that up 2 years ago. I don't know why is that, but staff seems that they hold the paralegals in high regard. They really think you guys do a great job. And I don't think that there's that issue of, gee, don't harass us, but we're not going to give you the answer you want. Just keep arguing with this. None of you wants to get the reputation of being that person, so they want you to have a different reputation. So I just want to say the staff has commented that that relationship between the clerks and the paralegals seems to be really good, and they appreciate what you guys are doing. And if you have any issues with them, if they staff as well, then let us know. But I think they're all very professional. They're very cooperative with all of you. So having said that, any other questions, any other comments? Happy to hear whatever's on your mind.
Judge Mackey, if you don't mind, I've been reviewing the local rules. I know that there are some proposed changes coming up. I was wondering if you might be able to talk a little bit about Rule 7810 as it pertains to special needs trusts, and if you could just maybe talk about the changes that are coming in regards to that. And that might be a very specific question we can follow up with later.
I don't have the rules in front of me. So 7810 or special needs trusts, are you talking about setting them up or acting for expenditures out of them? What is 7810?
Yeah, sure. So it talks a little bit about the requirement for the trustee to be able to post bond, making sure there's not a discharge of support from any other parties, and then just generally talking about requirements for them to be court supervised. So I'm wondering if the rule change that is coming about is intended just to make that rule a little more concise, or if there are other substantive changes that maybe I haven't picked up on that are coming forward in that.
Yeah, no, that's a good question. Thank you for that. And without having the rule in front of me, I think what the intention of that rule was just try to put down in writing some practices we were already things we were already doing here at the court. When we have a special needs trust, we get oftentimes applications, the trustee, the family, the parents, whatever, they want the authority to expend money out of the trust for various reasons. And so our magistrates have a series of things that they look at when they're looking at whether to approve that. Again, if it's something that's already the obligation of the parents, it's going to be, paying for their support. That's a parental obligation, especially if it's a minor. We don't really want the special needs trust to be paying for that. Another issue we see this with some regularity is the family wants to, maybe these are kids that are kids under 18, perhaps over 18. They want money to improve the house to more adequately address the special needs of that kid. Sometimes these spenders can be really large. So we have no problem with that, but the magistrates look at particular things. They want to know estimates for the improvement, who owns the house. So if they're just improving the house that the parents own, what happens when the kid dies. So these are issues that usually come up with an application to expend funds out of special needs trust. And the magistrates could have some very specific questions. And I think that's what the intention of the local rule down in writing was about, but to try to put down in writing the process of actually using with those expenditures. We oftentimes, not often, but with some regularity, get applications that they want to spend hundreds of thousands of dollars to buy a different house, which can be more appropriately addressing the needs of the beneficiary. And we will approve those, but we look at those very carefully in terms of what's the longevity, the life expectancy of the beneficiary, what other resources do they have. They use all this money for the house, they're going to be enough resources to adequately provide for the beneficiary for the rest of their life. So I think the intention of that rule change, and how this is really just to kind of put down in writing. I don't think it changed things. I think it just tried to document what we were already looking at. But if you have any comments about that or any questions about that, by all means, send those into the website and respond to that. We're looking at this to address whatever concerns the practitioners.
Wonderful. Thank you so much for your help.
And Judge Mackey, I believe the deadline for submitting comments on these proposed rule changes is tomorrow, December 1st.
No, I don't think that's correct. I think it was 90 days. So I think We are, so, yeah, I don't know if that's what it said or not.
No,
But-
that's information from the Columbus Bar Association's
Oh,
email yesterday.
I
Oh.
believe December 15th, Angie.
Okay, thank you.
sorry, what did Tony say? What-
She said December 15th.
Yeah, I think that's correct, because there's a 90-day comment period, and they went up on November, and
Okay,
those 30 days. So
I
I,
will-
December 15th, we'll certainly take comments right up to January 1st. Early January is when
Yeah.
we can submit to the Supreme Court what our local views are, so I think the deadline is December 15th. If we get comments come in after December 15th, if we can incorporate them, that's fine. So no, I don't think the deadline is tomorrow. I gotta check if the Bar Association said that they were not correct.
okay, thank you.
They've been out there since November 15, and I think the comments are up to December 15. And then we finalize things and then we file with the Supreme Court what the local views are. So, great.
Okay.
Verify that. Anything else? As Dean woke up, he's back here now, so. All right, well, thank you all for having me. I hope that was some helpful information, and we're always, because I've practiced in the probate area for so many decades. I'm always very interested in what practitioners, that includes paralegals, have to say about why do you do this way, or couldn't you do this way? It would be a lot better. I am always open to those comments. When I came on the bench and we did some really crazy things, I thought, why are we doing it that way? And I said, well, that's because we've always done it that way. And I said, well, that's not good enough for me. So we've changed a lot of processes just to make it easier for the practitioners, because if you have stupid rules that have been there that don't make any sense, why do we have them? And just because we've always done it that way is a really crappy answer in my book. So I'm always happy to look at different ways of doing things, and oftentimes if you ask them, do it that way because of such and such. And, oh, okay, now I understand. So that two-way conversation, we really love that, and do not feel like you're putting upon us if you have some suggested changes that we do.
Okay.
Okay, great. Well, everybody have a nice holiday. If you don't have anything further, I hope you. This is a full week. Last week was a short week, but this is a full week, and we're getting a lot done. And I always say on Monday morning when I come in, I always tell my staff, "This is going to be the best week ever." And then usually by Monday afternoon, they're like, "You know what, that best week ever thing? Let's forget that. Maybe not this week, maybe next week." But we try to make every week the best week ever, and we appreciate what all you guys are doing. It really helps the administration of justice and administration. What you're doing.
Thank you.
Great. Thank you so much, Judge Mackey. As always, it was a pleasure. We thank you so much for sharing your time and your expertise with us, and sharing this very important information. I know it's going to be helpful for a number of us. Thank you all for joining us this afternoon. A couple of reminders. There are two events coming up in December. One is the Workers' Compensation Roundtable. That is on December 13th. And at that time, Attorney Mark Shaw will be joining us and discussing the passage of Issue 2 and what impact, if any, legalized recreational marijuana usage will have on Ohio workers' compensation claims. And he'll also be discussing the rebuttable presumption defense for claims where an injured worker perhaps was under the influence of a substance at the time of the injury, and whether that impaired their ability to do their job properly and affected directly caused the injury. Also on December the 19th, at our general membership meeting, Marissa Bowers of Oblick will be joining us, and she will be discussing with us some ethical considerations in the use of AI. Those both sound like very interesting presentations. And for the Workers' Comp Roundtable, I know that's a topic that may be of interest to people outside the workers' comp practice. Certainly anybody is welcome to join. Both of those events are up on the website. You can register on the website. I would encourage you to do so. And with that, I will wish you all a very happy and joyous holiday season. And thank you so much for your time. And we will see you next time. Thanks so much.
Thank you.